Lawyers of Reddit, what's the most ridiculous argument you've heard in court? I'm a lawyer. The most ridiculous argument I've seen was one I actually made. One of my clients got busted cooking meth. This was a very clear-cut case. They actually caught him in the middle of a cook. No way he was getting out of this one. Even worse, he was cooking at home, and children were there. Yep, the DA loaded him up with felonies, there was no bail, and he was being held in the county jail. My client knew he was faked. He had been planning to get married a few weeks after he got busted. My client asks me if he can get released for 24 hours so he can still get married. I tell him that I'll ask, but that there's no way in faking hell they'll let him out. First, I ask the DA if they will allow it. Nope. They laugh. So I file a motion with the court. Now, I knew the judge was a crusty old conservative family values kind of guy who also has a raging erection for drug crime. There was no law involved, but I put together an argument about the sanctity of marriage and how the state should encourage marriage at all times and that sort of thing. We have a hearing and I make the argument. The DA is totally opposed and calls it ridiculous and the judge grants it. The judge actually decided to allow my client out for 24 hours to get married. He had to surrender at the county jail at 8 AM the next day and some other conditions, but still, he was allowed out. Everyone is stunned. Nobody can believe it. The day of the wedding comes, my client gets out, gets married, then goes back to the jail. Everything went exactly like how it was supposed to, which is also pretty shocking. Several years ago I was doing a civil trial, personal injury, defending a woman who, allegedly, hit a bus matron with her car. We had offered to concede liability and just try damages. In other words, the jury wouldn't hear the circumstances of how the injury happened, just that we agreed my client caused the injury, and they would only decide the amount of damages. We had evidence that the plaintiff was significantly exaggerating her injuries. The plaintiff's attorney refused to agree to our concession, thinking that if the jury heard the circumstances they'd want to give even more money to punish my client. So we went to trial on liability. The plaintiff called one witness, her client, who testified that an older woman in a green car hit her. They rested and I moved for a dismissal for failure to prove a case. There was literally no evidence connecting my client to this incident, just an older woman in a green car. The plaintiff never bothered to call my client to the stand. The attorney told the judge that the bus driver had written down my client's license plate and gave it to the police. They never bothered trying to find the bus driver. The attorney asked if she could just put the police report in, and I objected that it was hearsay. The attorney then actually said, please just let me put this in. I haven't had work in a while, and I got retained by a firm to try this case. I really need to win this. Of course I didn't agree, and the judge dismissed the case. I felt a little bad for her, but that was maybe the worst presentation of a case I ever saw. I spoke with the jury afterwards, and they all said they hated the plaintiff, didn't believe a word she said, and likely would have found in my favor anyway. Moral of the story, be prepared in court. I'm a prosecutor now, but I used to have a private practice where I did a lot of evictions. My usual landlord clients wouldn't even come into my office until their tenants had been behind for months, and most of the time the tenants were defiant in their non-payment, so it wasn't difficult to not take pity on them. Anyway, one tenant was a particularly dumb guy. He usually came to court dressed in a wife beater and cute off jeans. We had a trial date set, and my client and I showed up. Tenant did not. At the last second before the judge entered a default, some woman comes bursting into the courtroom and yells, "Daryl's on the phone." The judge allows her to bring the phone up, and we put tenant on speaker. He proceeds to ask the judge to delay the trial for 1 week because my brother got his head knocked inside out and is probably gonna die. I didn't buy it, but my client knew Daryl well enough to sense the stress and fear in his voice. I told the judge that we would allow the continuance, but only until the next available court day. The judge set it for 1 week out. I still didn't believe Daryl until that night my grandfather was in an accident, and we had to rush to the hospital. As we're walking up the hallway, I see Daryl in a room with a bunch of people who dressed like him enough to obviously be family. When we get to my grandpa's room, He ended up being not as seriously injured as we originally feared. The first thing he says is, "You'll never guess what happened to the guy down the hall. Nurse told me his idiot brother dropped a tractor bucket on his head and opened it like a cracked egg. He's in a coma now." I relayed the news to my client, and she felt sorry enough for Daryl that we signed an agreement stating that he would clear out within 15 days and we would forgive all back rent owed. Actual lawyer. What I dubbed the surprise party defense, in a hearing for an order of protection in which ex-wife is trying to get an order of protection against ex-husband who had been stalking her. They have a high school age child together. Ex-husband tries to argue against the order of protection by saying they may need to be able to communicate about the child. The judge points out that they can communicate through the child, and also that other family members have been put in place by the juvenile court to be intermediaries, re-pickup, drop off, etc. Then ex-husband has a brilliant light bulb idea. "Judge, what if I need to throw my son a surprise party and I need to keep it secret from everyone, but his mom still needs to know so she doesn't throw a party the same day?" In other words, while I admit have been stalking my ex-wife and that there are grounds to grant an order of protection, you should not grant that order just in case I need to throw a surprise party one day. What made it was how clever he thought the argument was. Thus was born the surprise party defense. Edit. A lot of you are upset about the comment of communicating through the child. That was probably a poor way to phrase it. In this situation, the father would be barred from passing messages to the mother through the child. He can't say, "Tell your mom X," but, of course, some indirect communication is going to occur, and that is what the judge was referring to. In other words, the father cannot argue that he needs to be able to have direct communication with the mother for purposes of coordinating child care, things like that, which is often the issue. Because the child in this case is old enough to tell both parents, for example, about school, friends, trips, grades, etc. It is not as if the judge ordered the child to be the intermediary. That is ridiculous. Also, I sort of simplified the complexities of it because these people's parental arrangement was not the point. The dumbness of the argument was the point. But this is a criminal judge determining an order of protection. There is a whole separate juvenile/family court judge that actually determines the custody arrangement and things of that nature. The bottom line is, the guy was trying to use the kid as an excuse to avoid an order of protection so he could continue to stalk and harass his ex-wife. Long time lurker, but I couldn't resist this one. Not a lawyer, but I was called as a witness to testify for the state regarding an accident that I was involved in. I was hit from behind by a large construction dump truck while sitting at a red light behind another vehicle. It was a 4-lane roadway that merged into 2 after the light, and I was in the right lane heading north. The light turned green, and I hadn't moved yet because I felt the vehicle tap mine. Next thing I know, I'm moving forward, and I begin to panic that something's wrong with my car. Well, apparently the driver of the dump truck didn't realize he'd hit me and pushed me straight through the intersection, and my car ended up doing a 180, and I was facing south heading towards a very deep ditch. I was blaring my horn and hitting my brakes and trying to avoid going in the ditch because my son was not even 1 month old at the time and in the backseat along with my dog. I managed to pull the parking brake and we slide to a stop just at the edge of the road before the ditch. Husband turns and asks, "Do I need to call 911? I tell him no, because I see the dump truck pull over to the side a bit north of me and I figure he'll come out to exchange insurance. Lo and behold, the driver took off after about 15 seconds of sitting there. I was stunned, but immediately told hubby to then call 911, that we'd be in a hit or run. Sheriff comes. People from the company that hit us come. Witnesses who saw the whole thing tell the sheriff what happened and company apologizes. They start looking for the driver through the GPS on the vehicle. Company ended up paying $2,000 in damage to my car and paid for a brand new car seat. Pictures were taken by all parties as well of the damage present to my car, so imagine my surprise when I got subpoenaed to appear in court to testify against this guy. I can't believe the nerve of this asshole that hit me, ran, and had the balls to testify not guilty to the charge. The day comes, and I show up in court, give my testimony, witness gives hers, sheriff gives his. A bit of banter back and forth about a surveillance video from a gas station that the driver obtained, but his dipshit lawyer didn't bother to enter into evidence before the trial. Judge won't allow her to show video because state hasn't had time to review it. We finally get to hear the driver's testimony and he gave the best excuse that could be summed up like this: I didn't see her car as I was pulling up to the light. I was giving enough distance to stop to the car in front of her, but I didn't see her. I didn't hear the horn blaring because I was in a diesel vehicle and didn't realize that I'd hit her or that I was even involved in an accident, and that's why I didn't stop. I'd been having brake issues and thought it was just my brakes acting up. He apparently thought he could win his case by testifying that because he didn't see me and didn't realize he was in an accident, he shouldn't be charged with the accident and failure to remain at the scene of the accident. Sorry, asshole. Ignorance of events doesn't make you any less liable in the eyes of the law. Judge pronounced him guilty and the guy rolled his eyes like he couldn't believe it. I'm still waiting to find out if he tries to appeal at point edit. Typo. I wasn't a lawyer, but a law clerk working with the prosecutor's office. This guy was caught on the highest quality security cam video I've ever seen stabbing a store clerk like 15 times. She survived and then was tackled a block away from the scene not 5 minutes later by a man who had seen him flee and followed him 25 feet from the knife and the jacket he'd been wearing that was covered in blood with a receipt with his name on it and the pocket point. It was the literal definition of a slam dunk case. The guy chose to proceed to trial without his lawyer instead of having the case postponed after his attorney's house was broken into and all his files were stolen. This guy's main argument was that it wasn't him because in the statement of probable cause written by the officers after the incident they misspelled his highly unique last name by adding a T in the middle. For instance, Johnson became Johnston. He spelled his name out at every opportunity with much emphasis. He also argued it couldn't be him because the man on the video tied a t-shirt around his head so that the distinctive tattoos there would be hidden, but he would never cover over his tattoos like that because he was proud of them and they represented his heritage as a Korean man. The jury took less than a half hour to return a guilty verdict. This came in a deposition, but it's still one of my funniest stories from this old job. I worked part-time as a paralegal when I was in college. We had this massive case with a lot of people involved that had spun out into a bunch of little side cases. In one of those side cases, this guy was claiming our client had left him threatening voicemails related to the main case, and him and his wife sued for loss of consortium. Loss of consortium, and I swear to you this is a real thing, basically means something happened that is stopping a married couple from having sex, and they want to sue you over it. The guy was claiming that he was so scared from these voicemails that he couldn't sleep with his wife anymore. Deposition time rolls around and I'm sitting in the other room, but it's a small office and I can hear everything. My boss starts asking the wife how we are supposed to know that it was our client's fault they stopped having sex. Maybe she's just not as attracted to him anymore. Maybe he's not attracted to her. Maybe they didn't have that much of a sex life to begin with, etc. So this woman starts yelling "I love sex" and banging her fists on the table. Her lawyers try to calm her down and tell her to stop talking, but she keeps on shouting "I love sex." We used to have sex 2-3 times a day. We'd be thrown out of hotels because of the noise we'd make. And to the protestation of everyone in the room, her counsel and ours, she proceeded to describe their sexual history in graphic detail, all of which was recorded in the deposition and filed with the court. Labour who is not practicing in court, but when I was in college doing my bachelor's degree, criminal law was part of the curriculum and this included spending a couple of days observing criminal trials. The things you witness anyway. At the start of one of these trials a guy with the greasiest mullet enters the room. Thin, tall, disproportionately sized limbs, tattoos all over. I swear the way he sat before the judge, the only thing that was missing was a beer in his hand and a chicken under his arm. Now, this guy chose not to have a lawyer represent him, as he's a regular, and spends short periods of time in jail, or doing community service pretty much every month. Anyway, Real problem case, drugs, alcoholism etc. But still he comes across as a really sympathetic dude and has a really entertaining way of telling a story while keeping a straight face and not realizing how funny he is. He knows he's getting fined and a couple of hours of cutting weeds as community service to keep our Dutch streets nice and tidy, but tries to win the sympathies of the judge to decrease his sentence. This man's dog was sent to a dog shelter when they found it malnourished a couple of weeks before when they brought him in for dealing. Real sad, but also the reason he's standing trial. The guy got high as a kite and drunk as an Irishman on St. Patrick's, and while completely drugged out of his mind decided to get his dog back from the shelter because he really missed his girl. The judge asks him if it's correct that he broke the lock and some of the camera equipment on site of the dog shelter, and he confirms. You could really tell from his passionate account of the progression of the evening that he did all this out of pure love, as his dog according to him was the only thing that pulled him through all of his rough patches with his girlfriend and his drug problem. So the judge orders camera footage to be shown to confirm that it is the suspect, and he confirms. On it he is seen stumbling about and wrenching one of the dog enclosures open and hugging a German Shepherd. At this point everyone is touched by seeing this guy be so emotional on the camera footage with the dog, hugging it, petting it and playing with it, and you can see the judge really get into it as well. Anyway, so this guy continues with his story and tells about how he took the dog to his car and went home never feeling happier in his life, and ends his account with the driest delivery of needless to say I was faking surprised when I woke up the next day and there was a German Shepherd in my room instead of a Staffordshire Terrier. Everyone just broke out in laughter. He didn't get what was funny. Turns out the dude stole the wrong dog. Judge sentenced him to 50 hours of community service and €3,000 or so repairs for the broken doors and camera equipment. TLDR guy tries to win sympathies of judge with passionate account of how he broke into a dog shelter and steal his dog back from animal services. Steals the wrong dog. Not a lawyer, did work experience with one back in high school. He had to go speak to someone in the court cells where I wasn't allowed, so I went and sat in one of the courtrooms. While he did that, there were a few cases, but the one that stood out were the two guys who both had some injuries and claimed the other one had attacked them unprovoked. Neither wanted any representation. There was no evidence apart from them blaming each other, and when the lawyer I was with came to find me, they were literally just stood in front on the judge screaming he did it / no he did it over and over again. Edit. Just thought of another story from a close friend who's a defense barrister. Her client was a building firm that had done shoddy work on an OAP's roof that had led to it collapsing, causing the OAP a head injury and fractured hip, so were being sued. She said the damages were wildly inflated in value by the prosecution, but her client was even more ridiculous with their offer. Her research had shown her that the minimum they should have been offering for the collapse of the roof alone, without the additional injuries, should have been £4,000. They refused to offer more than £1,600 on the grounds that they expected her to die before anything happened as a result of their work. She said she'd never felt more embarrassed than when she had to tell the judge this in front of the prosecution and their client. When I was clerking for a judge in my first year as a lawyer, we had a case that centered around if a person could lawfully shoot a dog that is attacking his chickens. The law said that he could shoot him if the dogs were bothering or wounding the chickens. Plaintiff was suing for the value of his dogs that were killed and emotional distress. His argument was that the dogs were not bothering or wounding the chickens because they were running away when the farmer came outside with the shotgun. He then argues that wounding has to be active. So he gave an example. If the dog has a chicken in his mouth you can shoot. If he drops it, but the chicken is floundering right in front of him, you cannot shoot as the wounding has ended. Picks it back up. Shoot the mutt. Likely paws at it. Not wounding. It was ridiculous and inconsistent with case law. I wrote the opinion awarding defendant summary judgment. Here comes my favorite part. Plaintiff asks for a reconsideration based on a single word I used in a throwaway line in the 8-page opinion. I said it was reasonable to assume that the dogs were still a danger to the chickens. During the reconsideration, the partner from the firm comes for plaintiff instead of Joe Schmo and says, frankly judge, I have always thought you were the finest attorney in the region, so I'm shocked you got this so wrong. It's baffling to me. Judge didn't react, but I was plenty offended on his behalf. So I am tasked with writing the reconsideration opinion. I wrote a 2-page summary of the hearing with no indication on the 2 pages which way we were leaning, then pasted the original 8 pages, but with the sentence about reasonableness, omitted. Point I wish I could have watched that lawyer read 3 pages deep to realize it was the exact same decision as before. Not a lawyer, but I testify in criminal court regularly due to my job. Point anyway, one morning I was sitting in a misdemeanor courtroom and watched a well-dressed mid-30s Polish lady step up when her name was called. She was charged with the crime of failure to pay bus fare, about $2. Instead of just paying the minimal fine, she went full retard and decided to defend herself pro se against this clearly heinous charge. She then proceeded to give a 45-minute oral argument that stretched my understanding of reality. At various points in this impassioned speech she dropped to her knees and prayed, invoked the Archangel Michael, and began flapping her arms like wings. The judge was not amused and sat there listening with his head in his hands, but he couldn't stop her, of course. Eventually she finished, and he immediately found her guilty and ordered her to pay something like $40 to the clerk. This only made her angrier, and she began the whole flapping of the arms thing again and arguing with the judge. At this point, the judge explicitly stated, "I want you to leave the courtroom now. If you make one single noise on your way out, the deputies will arrest you for contempt." 2 deputies started inching closer to her. They never get much action working courthouse duty, so they were excited. She looked defeated and began to exit, but just at the door she turned around and opened her stupid mouth once more to call the judge a cursed demon. Everyone applauded as she was dragged out in cuffs. Defendant wanted to take back his guilty plea, arguing that the only reason he pled guilty was because he had to take a huge sheet at the time, but didn't want to do so at the courthouse. Point another defendant argued that it was denied the effective assistance of counsel because his defense counsel permitted him to plead guilty to a DUI 20 years ago after the guy crashed his car into a wall and was drunk off his ass at 5 AM in January. His defense was that he crashed his car, then in the 30 minutes, 1 hour waiting for the police, walked in the freezing cold to a liquor store and drank a whole bottle of whiskey, and so he wasn't technically driving while intoxicated, but became intoxicated afterwards. The judge described the guy as either highly courageous or highly foolhardy for offering that story. Different defendant claimed his guilty plea was not knowing, intelligent, and voluntary, and therefore invalid because he was high as shit off cocaine and alcohol when he came into the courthouse at 9 am. I've responded to countless motions from defendants who've said that they didn't know they'd be deported if they pled guilty, even though the judge explicitly told them exactly that. One defendant claimed that he couldn't have committed the robbery by climbing through the bathroom window because he has arthritis and knee and hip problems. He testified to this, despite knowing that we had security footage of him climbing in through a window of a church, also to rob it, then jumping up and climbing out, and despite knowing that the judge was going to allow us to show it to the jury if defendant opened the door to such evidence. Non-citizen defendant who's a level 3, highest, such offender argued that his designation should be lowered/removed because he was deported, and therefore he doesn't present a danger to the community anymore. Not a lawyer, but I do have a story for this. This happened while I was working as a medical assistant. One of our diabetic patients got a speeding ticket while his blood glucose was low, and he seemed to be under the impression that this would be an ironclad excuse to get him out of it. So he calls our office one day, and I answer. Part will be the patient. Me, drive X's office, not his name, if that wasn't obvious. Theatrical speaking. How may I help you? Part. Hello, TDW. I need the doctor to write a letter for me. Me, I can definitely help with that. We do this frequently, usually for a jury duty excuse, or a note stating they need to bring their medications with them when they travel, etc. What is the letter for? Part. I got a speeding ticket last weekend, and I'm going to contest it. I need a letter from the doctor stating that I have diabetes, and that it impairs my ability to drive, so it wasn't my fault I was speeding. Me. Let me run through this with you, just so I'm clear what you're asking for. Part. Okay me, you want a letter stating you have diabetes. Part. Yes me, and you want it to say your diabetes impairs your ability to drive. Part. Yes me, and you believe telling the judge that your diabetes impairs your ability to drive will get him to throw out the ticket. Part. Yes me, I don't think that's a good idea, sir. Part. What? Why, me, even if they agree with your argument and toss out the ticket, which I doubt they will, if you tell them that you have a medical condition that impairs your driving ability, I'm pretty sure they'll take your license away. Part. No, see, I'm only impaired when my blood sugar is low me, right? But this would go on for a few minutes before I told him I'd ask the doctor and see what he thinks. Unsurprisingly, the doctor agreed with me, said he would lose his license if he did that. So we didn't write the letter, but he still brought this argument to traffic court. The patient is now driven to his appointments by his family members. I was a state witness in a parental neglect trial. As an LCSW, I worked for a mental health/substance abuse hospital evaluating children and teens for admission. The state was asking to have the kid removed from the home, in part due to information I reported, as I had admitted the kid on 3 separate occasions. During one eval, the mother shows up so high she can barely talk. The kid admits he gets all his drugs from her. The other evidence comes from info gathered during the kid's inpatient stay, so this a very rural area with only 2 hospitals in the entire state. As such, I didn't work in the hospital, nor was first part of the inpatient staff. I live 3 hours west of it, covering the 22 counties on the west side of the state. The prosecution had sworn statements and records from the inpatient staff and called me because I lived in the jurisdiction of this court and could testify in person. So all of this information was introduced the minute I took the stand. The defense lawyer basically repeats all of this and then proceeds to try get me to support his defense that the inpatient treatment was inadequate. How this relates the mother giving the kid drugs no one ever figured out. He has absolutely no witnesses of his own, no character references, no other hospital staff, nothing but the state's evidence and me. He repeatedly asks if I agree with his statements that X occurred in treatment, or that if Y would have been a better option. After like the 6th time of me stating I was not able to answer the question, the judge cuts him off and asks if he has any other line of questioning. The mother whispers in his ear and he says yes, he has one more question. Do I think the mother is a fit parent? I was stunned. I looked around at everyone and asked him, are you asking me in my professional capacity if I think the mother is fit to parent? I see the state just kind of smiling and shaking his head. The defense is certain and says that's what he's asking. I look at the judge, who smiles and nods at me to answer, so I say, no, in my professional opinion she is not currently fit to parent. Everyone else is trying not to laugh, but the defense looks so disappointed I almost felt sad for him. I don't know what the fuck they were thinking, but needless to say, the state won. I'm a little late this one, and am not a lawyer, but was involved in recording proceedings of a case. The case was a major fraud case. It was multiple organizations involved, and a lady was defrauding them through bad checks. She also had the eyes on her, since she would use the receipts she got for the bad checks from charities to add deductions to her tax bill. I don't remember the exact amount of the money taken, but I remember it being something astronomical that made me surprised she hadn't been busted well before then. She was writing checks that she didn't have the funds to cover to charities. She would also write checks to herself, deposit it, and banks typically allow you to recover part of the check, typically $200 to $300, until it's fully processed and goes through, and she would pull that money out of the ATM and use it for whatever. So there was a massive case built up against this lady by the state and these organizations, and she was facing several years in jail. And instead of pleading the fifth, she took the stand, and her defense was that since she was able to withdraw those amounts, it's the bank's fault. The money is missing, and not hers for the stolen withdrawals. She also tried placing blame on the charities for her eyes scam, since they gave her a receipt to use. Total lack of remorse or responsibility about misuse of her checkbook to defraud organizations. Her defense lawyer managed to get the case drug out over months. That guy must have somehow been getting paid to delay the trial as much as he did to keep her out of jail. Lawyer, but not a trial lawyer. corporate, so I never go to court. I will, however, relay a story one of my colleagues told me. This lawyer and a more senior lawyer were representing a defendant on some matter, and part of their argument relied on the plaintiff not mitigating their damages with respect to a car accident. The plaintiff claimed that they were not able to get their car repaired because no shop in the city had time to do the repairs, or some flimsy argument. So during cross-examination, the senior lawyer from our firm asks the plaintiff which mechanics shops they had contacted. The plaintiff basically stammered and said they couldn't recall. Lawyer, well, let's see if we can refresh your memory. Pulls out a yellow pages phone book, drops it on the desk and flips to the mechanics section. Lawyer, starting with the first shop. Did you call this shop? Plaintiff, no. Lawyer, goes to next shop in the phone book. Did you call this shop? Plaintiff, no. Lawyer, goes through the entire section in the phone book, asking if the plaintiff has contacted any of the shops in the city. The answer is invariably no to each one, basically demonstrating that the plaintiff had taken no steps to mitigate damages. Lawyer, I'd like to enter this phone book into evidence. Judge, denied, on the grounds that I'm pretty sure we already have one around here somewhere. Not a lawyer, but served on a jury where the guy had been pulled over and the lead police on a high-speed chase to his house where a major grow and distribution operation was going on in the basement. Also heroin and cocaine. The whole thing was captured on HD cruiser and body cams. I'm surprised it went to trial. Anyway, we watched both the body cams and cruiser cam vids. It was broad daylight. We saw everything. The defendant and his lawyer argued it wasn't him driving the car, it was his friend who jumped out of the car and ran through the backyard away from police. He also argued that he was in the basement bathroom doing his daily hash till the whole time when police just busted in and arrested him for no reason. It got cringy when we got to grow/distribution part. He and his lawyer argued it wasn't his house. Why is that ridiculous? The entire time he is on the stand, his lawyer never should have put him up there. He would say things like, I pulled into my driveway. I mean, my friend borrowing my car pulled into that driveway where I was staying. The police had mail addressed to him at that address. He again would say stuff like, I had my mail forwarded to my house. I mean my baby mama's house while I was away. That's not my name on the assessor's tax bill, but my friend who has the exact name, and somehow they got the SSN mixed up, so it looks like it's addressed to me. Just kept on incriminating himself the whole time. It was bad. TLDR, HD cams caught the whole thing. Overwhelming evidence that he did live there, but claimed it wasn't him, and that the mail was for a friend with the same name. We found him guilty on 8 of 9 counts. Am lawyer, and I'm probably cheating. TLDR, quantum tunneling. Most ridiculous argument came from a pro se defendant in an eviction proceeding. Our firm represented the landlord because our firm always represented that landlord, and we don't usually have to take things to court, and when we do the defendants don't usually show up. The defendant was being evicted for discharging a firearm inside her apartment at about 3 AM, the bullet of which passed into the apartment of her downstairs neighbor. She had also broken into another neighbor's apartment late at night, broken the glass on the door and let herself in, and terrorized the guy, but for whatever reason he didn't want to come testify in court. Everyone was well aware that she was mentally ill. No one gets evicted for being mentally ill, so we all just tried really hard to focus on the plain facts and not bring up anything that made the defendant look crazy. She did it for us. She testified to the court that she was an alien abductee, have been all my life, and that the night in question was the anniversary of the night she had been abducted by reptilians. She had been wandering around the house, brandishing her gun for self-defense, and she had heard a noise. She even had pulled the trigger, she said. But, she said, the gun did not fire. Our testimony had included the police officer who had identified bullet holes in the floor of her place, the ceiling of her neighbor, the sofa of her neighbor, and the floor of her neighbor. She asked if we were familiar with the concept of quantum tunneling. Yes, she had been brandishing a loaded gun in her apartment, and yes, she had pulled the trigger, and yes, there may have been bullet holes. She disputed the location of said holes, but she hadn't fired the gun. She also brought as witnesses one of her friends, who wasn't sure that aliens existed, but was always willing to help the defendant look for them, because the defendant was always willing to help her hunt for ghosts at the nearby graveyard. The judge took all the evidence and arguments in, nodded, retired to his chambers, and left us waiting for a really long time. We were worried that the judge might show pity on the defendant because she was unwell. We had made a point that shooting a gun in her apartment, now, might have killed one of her neighbors, and that they had a right to safety in their homes. He finally came out and announced his verdict. He said that he had chosen not to disbelieve any of the testimony and that he found all of the witnesses credible. But then he busted out his Merriam-Webster's dictionary and found one of the possible definitions of discharge, and said that, while we normally think of discharging a firearm as, now, shooting a gun, discharge also includes the idea of anything which causes something to come out of it. So, even a quantum tunneling bullet would be a discharged firearm. I thought this was not a great decision legally, because that would also mean that unloading a firearm was discharging it, but this case was never going to see an appeal, and he made an unwell defendant think that they had been heard properly, so it worked out pretty well in practice. Okay guys, fixed the 8-foot katana to the 8-blade. Thanks for spotting the mistake. Not a lawyer, but recently stood witness, victim, in an assault by beating case, where I had been attacked with an 8-knife. The other guy was my then roommate at university, who was 30 years older than me, also a student. He had been intimidating and threatened to the three of us in the flat, shouting, telling us he'd been in prison for beardophilia, smearing food, ECT, all over the kitchen and whistling. This came to a head when he told me he would kill me and then came at me with an 8-inch carpenter's blade. He pleaded not guilty. I got called in. I was accused of making this all up because I had been in Doctor Who. I've never been in Doctor Who. He said he had been making a Nike table in the corridor. Corridors roughly fits 2 people side by side, using the knife. Plus how'd he fit the finished table through the door? And that was why I knew what the blade looked like. Seized by police, hidden in his room. They then said I had come up with this with my female roommate and implied I was sleeping with her. She has a girlfriend. I'm a guy. No chance regardless. At the time though I was faked and he'd get off. But it turns out the court saw through this and charged him, but only with a fine. Probably due to his status as a student. Not a lawyer, but was jury foreman on a particular case. It involved a college-aged kid potentially going to the big house for carrying an illegal weapon. Long story short, the kid was from out of state and got pulled over, and the officer saw the weapon. The kid was arrested. In court, the defendant attorney introduced a document to where the kid that was riding in the passenger seat admitted it was his, but he would not come back to our state because he knew he would get arrested. Counsel starts reading off confession. After it was over, the prosecution objected to the document being presented. Both parties approached the judge and the argument ensued. Judge dismisses us because the courtroom was too small to keep the conversation quiet enough for us not to hear. After 10 minutes, we were called back in and everything proceeded. After all was done, we found the defendant not guilty. Counsel had an opportunity to question our decision afterwards, and prosecution asked me why we felt the way we did. I said the letter that was presented was enough to give us a reasonable doubt to the weapon being his. Prosecution was baffled. They said we were supposed to disregard that letter because of whatever the issue was. I said, but we came back into the room and everything continued. Nobody ever said for the jury to disregard. We heard what we heard and nobody said to disregard it. They ran back and sifted through the transcripts and sure enough, they failed to inform the jury, myself in particular, to disregard the letter. Thus we used it to find the guy innocent. I got a parking ticket in Virginia once for parking in a no parking zone. In this city, all areas where you can park are outlined by a large box. No defined lines for each space. If there's a no parking zone, the box ends and restarts after that zone. I parked inside of the box, but apparently there were signs up that I just didn't see. Explained all of this to the lower court judge, who said, "Welp, you should have looked at the signs too instead of just the pavement." Later, I'm reading online in the county ordinances and it actually states my argument is a requirement under the law. The boxes have to end and restart. I go back to the court and appeal the matter. One day before court, I get a RAPS envelope with a motion to dismiss from the state because a code section they cite does not give the circuit court authority to hear parking matters. I look up the code section, and it doesn't say that at all. It literally says any matter not felonious may be appealed to the circuit court. Nothing else. They didn't even read their own code section they cited. Point. I quickly get a friend on the phone, who is an attorney. He starts writing right away, and then shows up to represent me the following morning. He argued that their motion was stupid because the code section doesn't back up their motion. Filed a motion for summary judgment because the county failed to appear and they were the original plaintiff, not the state. The clerk in the DA's office faked up by taking on the appeal instead of giving it to the county attorney. And then filed a motion for sanctions for the adder, sending me the motion the day before when it should have been sent at least 2 weeks prior, and also scheduled for a motion hearing when instead they intended to just drop it on me the night before, assuming I was unrepresented and wouldn't know any better. I got out of the parking ticket, but we didn't get the sanctions against the adder. She cursed out my attorney in the hallway for being a mean lawyer for him trying to get her roasted for her mistake. I'm a lawyer. I think I should get a cookie just for that. But I do have a story. Point. I'm an estate attorney, so my typical excitement is limited to squabbling heirs, which can actually be quite entertaining and sometimes very sad. But the most bizarre case happened when I was hired to represent a guy whose father had died a few years earlier. He was the executor of the estate and had, as is typical, hired a lawyer to do the probate, file the tax returns, etc. Point. The problem? Well, years had passed and the estate was not yet completed. And the lawyer he hired had stopped taking his calls and was refusing to give him any information about the status of the estate. This is definitely not normal, but at first I thought there might be a reasonable explanation. However, as I investigated further, I began to suspect the worst, that the lawyer had not done any work on the file and had stolen the estate's money. Point. First, he refused to turn over the file to me because his office flooded, he had the flu, a parade prevented him from leaving his office, and finally that he couldn't release the file unless he was paid $50,000 for his legal services. Then, after I petitioned the court to make him turn over the file, he failed to show up for the hearing, faxing the judge at the 11th hour to claim he'd been hospitalized with pneumonia. The judge held him in contempt and set another hearing, which he also didn't attend. But this time he sent his own counsel, who finally admitted that, yes, he'd stolen the entire estate. About $500K. Point. It turned out that he'd also stolen money from several other estates. Close to $1 million all told, if memory serves. Of course, he was disbarred and criminally prosecuted. He pled guilty to several criminal charges. To me, the most shocking argument of all came at his sentencing hearing, at which his minister and several well-respected lawyers from his small town argued that he should not be jailed. Keep in mind that this is a man who stole from his own clients because he was a good Christian. Point. He was sentenced to 9 months. This isn't exactly an argument, but whatever. My father is a lawyer. I remember he told me this story when I was a child, and it stuck with me, and I'm now 20. He always told me that when you get the information you're looking for, you should stop asking questions. He goes on to tell me this story. This guy A, he was defending, allegedly had injured some other guy B, in a bar fight. Guy B claims his nose was bitten off. Apparently they were talking shit while being shit-faced drunk. They decide to go out in an alleyway to go fight it out. A big crowd of people follow them and they start fighting. Eventually these two guys are on the ground and some way or another Guy B ends up with a ridiculously bloody face and half his nose missing. The cops are called, blah blah blah, and these guys end up going to court. Point. They're in court and a witness was called to stand and was being questioned. He first asks something along the lines of, "So you were there watching Guy A and Guy B were fighting?" And the witness replies, "Yes." He was then asked, "So then you must have seen Guy A bite off Guy B's nose?" And the witness replies, "Well, no, I didn't actually see him bite it off. My dad always says the lawyer should have just left it at that. He got the answer he wanted. The witness didn't see Guy B get his nose bitten off. But, as the story goes, he asked one more question. So then how do you know Guy A bit off the nose of Guy B? And the witness replies, well, I saw him spit it out. So yeah, that's all I can remember. Not a lawyer, but I was present for this particular argument. When I was younger, my friends and I found ourselves getting into petty trouble pretty regularly. Stupid things like vandalism, trespassing, etc. And, like stupid teenagers, we also got caught fairly regularly. Most of the time it didn't amount to anything, but this one time we, specifically a friend of mine, were caught trespassing at a construction site that had recently seen some rather large theft. So, we were caught, hauled off, and made to appear in court at a later date. That court date came. My charges were minor. As I was a minor, my friend's charges were a bit more severe as he was barely an adult and they were trying to tie him to the theft of construction supplies that had occurred. The DA and judge start reading off charges and talking legal jargon, etc. The judge starts reading off the lengthy list of seemingly redundant charges. Judge, minors in possession of alcohol, breaking and entering, vandalism, trespassing. My friend abruptly stands up in court and interjects as if he were his own lawyer, and a cocky one at that. Your Honor, we object to the trespassing charges. There were no signs stating trespassing as being prohibited. He then sat down, rather smugly. The judge was clearly annoyed at this, but seemed willing to ignore the breach of decorum. Son, I'm sure at a construction site of this size, and after numerous thefts, there were signs, regardless. My friend interjecting again, Your Honor, we are sure that there were no signs, as we had removed them weeks prior. Smugly sitting back down, as if he had just won the case. The judge, utterly baffled. Regardless, the absence of signs does not make trespassing legal. There was a long pause in the courtroom, with the judge, prosecutor, defense counsel, parents, etc. all looking at one another. There were a few audible chuckles, but the case proceeded. Using a throwaway here, for reasons that will become apparent, got a speeding ticket in a faking metro, coasting downhill with the engine off, for 10 miles per hour over. This was in an area where at a lean, 65 miles per hour highway went to 45 miles per hour right over a hill. I was struck by inspiration. I called my state's call. Before you decline, I called in a utility locate for a 5-foot radius around the 45 miles per hour speed limit sign. Called for this locate the day after I took pictures of the area that indicated no speed limit sign. Took the pictures while leaning against the actual sign, so it looked like the sign wasn't there. Turned in pictures by the deadline for discovery. Utility locator came out about a day later, painted the area marking out the utilities. The way that works is there is a record of the locate and the day, but they don't ask for your name. So now there is an official record of a utility locate in preparation for an excavation. I went out that night and dug a hole around the speed limit sign. So when the officer went out to take a picture showing that the sign was there, his pictures matched the ones I came to court with, showing that after I gave you these pictures showing no sign, you guys went out and installed a sign. Look, there was even a utility locate called in. It worked. Probably won't work again. Forwarded from grandma. These are from a book called Disorder in the American Courts, and are things people actually said in court, word for word, taken down and now published by court reporters who had the torment of staying calm while these exchanges were actually taking place. Attorney, are you sexually active? Witness, no, I just lie there. Attorney, what is your date of birth? Witness, July 18th. Attorney, what year? Witness, every year. Attorney, what gear were you in at the moment of the impact? Witness, Guxy sweats and rear box. Attorney, this myasthenia gravis, does it affect your memory at all? Witness, yes. Attorney, and in what ways does it affect your memory? Witness, I forget. Attorney, you forget? Can you give us an example of something you forgot? Attorney, how old is your son, the one living with you? Witness, 38 or 35, I can't remember which. Attorney, how long has he lived with you? Witness, 45 years. Attorney, what was the first thing your husband said to you that morning? Witness, he said, "Where am I, Kathy?" Attorney, and why did that upset you? Witness, my name is Susan. Attorney, do you know if your daughter has ever been involved in voodoo? Witness, we both do. Attorney, voodoo. Witness, we do. Attorney, you do. Witness, yes, voodoo. Attorney, now doctor, isn't it true that when a person dies in his sleep, he doesn't know about it until the next morning? Witness, did you actually pass the bar exam? Attorney, the youngest son, the 21-year-old, how old is he? Witness, he's 21. Attorney, were you present when your picture was taken? Witness, would you repeat the question? Attorney, so the date of conception of the baby was August 8th. Witness, yes. Attorney, and what were you doing at that time? Witness, Attorney, she had 3 children, right? Witness, yes. Attorney, how many were boys? Witness, none. Attorney, were there any girls? Attorney, how was your first marriage terminated? Witness, by death. Attorney, and by whose death was it terminated? Attorney, can you describe the individual? Witness, he was about medium height and had a beard. Attorney, was this a male or a female? Attorney, is your appearance here this morning pursuant to a deposition notice which I sent to your attorney? Witness, no, this is how I dress when I go to work. Attorney, doctor, how many of your autopsies have you performed on dead people? Witness, all my autopsies are performed on dead people. Attorney, all your responses must be oral, okay. What school did you go to? Witness, oral. Attorney, do you recall the time that you examined the body? Witness, the autopsy started around 8:30 p.m. Attorney, and Mr. Denton was dead at the time. Witness, no, he was sitting on the table wondering why I was doing an autopsy on him. Attorney, are you qualified to give a urine sample? Witness, huh. And the best for last. Attorney, doctor, before you performed the autopsy, did you check for a pulse? Witness, no. Attorney, did you check for blood pressure? Witness, no. Attorney, did you check for breathing? Witness, no. Attorney, so, then it is possible that the patient was alive when you began the autopsy? Witness, no. Attorney, how can you be so sure, doctor? Witness, because his brain was sitting on my desk in a jar. Attorney, but could the patient have still been alive, nevertheless? Witness, yes, it is possible that he could have been alive and practicing law. This was an argument that a lawyer I know used for a client who was charged with a DUI. 2 cops, 1 rookie 1 veteran, show up to the scene of a reported accident and find a drunk man stumbling around the crashed car. They ask him if he was driving, and he says that he was. They arrest him and impound the car. In court, the lawyer for the man is cross-examining the rookie cop and asks him, "You testified that Mr. X was driving under the influence and crashed his car into the telephone pole." The cop confirms that he testified as much. The lawyer asks, "And you say that Mr. X was extremely intoxicated when you arrived on the scene? So intoxicated that he was barely coherent, is that correct?" The rookie cop confirms this as well, while the veteran cop immediately sighs in disappointment. The lawyer continues, "And you didn't witness the accident. You only arrived on the scene after the accident, and the only evidence you have that Mr. X was driving is his own admission that he was." The rookie cop confirms. The lawyer addresses the judge. "Lord, if Mr. X was so drunk that he was practically incoherent, his admission that he was driving while he was this intoxicated can hardly be accepted as an accurate representation of the truth, and as there are no witnesses, we cannot say beyond a reasonable doubt that Mr. X was in fact driving the vehicle at the time of the accident. It worked. The man got off with no charges. It makes me sad inside. I'm an EMT and was doing medical standby at an ITA court for a psych patient. During his hearing, the mother was testifying against the patient and reported that the patient had taken a chair and threw it through the front window of her house. The patient then climbed through the window and attacked her, striking her with closed fists and choking her to near unconsciousness. The mother's room had called police and the patient fled before they arrived. Upon cross-examination, the defense attorney asked, "Why did the patient get so upset? He broke into your house and started attacking you." The Mother replies, "Oh god, I can't believe I have to say this. I used the last of his cocaine." During closing arguments, the defense argued that the assault would have never happened if the mother didn't steal the patient's cocaine. The judge ruled against the patient and sentenced him to inpatient treatment for psychiatric services. I did lots of standbys at hearings for psych patients. Sometimes the patients would represent themselves. One instance there was a witness testifying that the patient, male, was being sexually inappropriate and attempted to sexually assault her. The patient argued that he could not do it because the witness was clearly a lesbian, that she was fat and ugly, and that he had sex with much prettier women than her. As the judge was ruling that he needed to be committed to a psychiatric hospital, the patient interrupted the judge, stating, "You talk too much. Let's have sex." There was no sex after the hearing. Not an attorney, but I love the law. Officer pulls over my wife and writes her a ticket, he says, because she was driving 12 miles over in a school zone. She comes home nearly in tears because of how the cop treated her. I read every line on the ticket and realized that he's actually cited her for driving too fast for conditions and seemingly didn't clock her actual speed with radar. This was 1995. When we go to traffic court, the cop insists that I can't represent my wife. I do, and on cross, ask the officer where his eyes were calibrated and when the most recent calibration occurred. He makes up a bunch of stuff about how he's been trained and taken classes, and yada yada. The thought is that I care about how he could tell that she was speeding. I was really just dicing with him, and finally move on to the second argument. That Florida statute he'd cited her for allows citation of driver whose speed is otherwise legal but for conditions, fog, smoke, rain, etc. and who causes or is involved in a crash or loss of control that involves property damage or injury to a person. There was no damage/injury. The judge refused to dismiss during the trial and told us that we'd have his opinion within a week. I asked him, politely, that if the decision wasn't to dismiss or not guilty, that he do us the courtesy of documenting how he arrived at such a decision to assist us in appealing. He asked me if I wanted to be cited for contempt. A week later, we were advised that my wife was not guilty. Witness here, I'm not a lawyer. The family on my mother's side rents a strip of land with access to a lake, with lots of similar lots parcels on each side almost around the whole lake. Our next door neighbor, let's call her Amy, inherited her lot from her deceased husband about 20 years before this. He inherited it from his father. This father by marriage had some siblings who rented the lots behind those with lake access and would always come to one next to ours and go swim, but he wanted his peace and quiet too. So he made an arrangement with the property owners, so the renters in the second row had a 1-meter access to the lake without disturbing him. Nowadays these original renters aren't alive anymore, but their children and children's children are. Pete was one of those who still rent a plot in the second row to the lake and still use the small extra 1-meter strip to access the lake with his many children. But he didn't stop there. He trespassed onto her property, placed his family's swimming gear and similar stuff at the shore of Amy's plot for days at a time, shouted at her and her children randomly, destroyed property. Some children, his or his friends, urinated in her flower pots. It was very unpleasant altogether. Amy therefore put signs up with private property, do not enter ASO, but after a few years, we are only there during the summer, she had enough and sued him. I don't remember what exactly the charges were, and my English isn't good enough for that in the legal department, but I hope you can understand or guess what the charges were. My whole family were witnesses along with some other neighbors, but not all. Some said they wouldn't testify because they were afraid of him. He's a bully, but I wouldn't say that he's dangerous. The trial was postponed numerous times. I remember that one judge got promoted. Another said that he didn't have enough time to review the current law concerning the case. This went on for another 2 years. Then the day for witness statements came, and about 10 to 15 people testified for Amy's case, only his immediate family for his. When asked why he did all those things he said, I was thinking of buying this place from her. He wasn't. I just wanted to look if there was any damage from the storm. Every day for many years, she told me I could. Why would she sue him then? She's never there, therefore it's abandoned property. Doesn't work like that. Our families do that since 19x6. It's tradition. No, just no. And many more. I wasn't present for the sentencing, but the judge ruled in Amy's favor. But I did read the final paper from the judge detailing the case and her reasoning. It was the greatest and nicest FAQ I've ever read. Unfortunately my computer died a few years ago, and I lost it. TLDR. A neighbor sued someone. I testified. Neighbor 1. It was epic. Edit. Spelling of deceased. This took place in Charlotte, North Carolina. A lawyer purchased a box of 24 of very rare and expensive cigars, then insured them against, among other things, fire. Within a month, having smoked his entire stockpile of these great cigars, the lawyer filed a claim against the insurance company. In his claim, the lawyer stated the cigars were lost in a series of small fires. The insurance company refused to pay, citing the obvious reason that the man had consumed the cigars in the normal fashion. The lawyer sued and won. Stay with me. Delivering the ruling, the judge agreed with the insurance company that the claim was frivolous. The judge stated nevertheless that the lawyer held a policy from the company in which it had warranted that the cigars were insurable and also guaranteed that it would insure them against fire without defining what is considered to be unacceptable fire, and was obligated to pay the claim. Rather than endure a lengthy and costly appeal process, the insurance company accepted the ruling and paid $15,000 to the lawyer for his loss of the cigars that perished in the fires. Now for the best part. After the lawyer cashed the check, the insurance company had him arrested on 24 counts of arson, with his own insurance claim and testimony from the previous case being used against him. The lawyer was convicted of intentionally burning his insured property and was sentenced to 24 months in jail and a $24,000 fine. This comes from an assistant DA who was doing a short class on law. Here is a summary of what happened. Person gets pulled over for something minor like a tail light being out. Person in back just happens to be a wanted felon. Felon, who we will call Jim from now on, panics. He runs into an adjacent cornfield evading a cop. The cop makes contact with Jim trying to get him on the ground. Jim goes for the cop's gun. Bright guy. Face to face with Jim, the cop draws and fires 2 shots. One grazed along the side of his head. Jim reads to one side and gets shot in the ass with the second round. Fast forward. Jim is at court. The defense was attempting to argue that Jim was shot from behind. This is because the bullet wound left a mark on his head. This mark started out small and then got bigger. Defense said that the bullet disintegrated as it got farther along his head, thus he was shot in the back, so to speak. This isn't true, because bullets get larger as they break apart. Now this is where stuff gets real. Jim pulls down his pants and effectively moons the jury to show where he got shot. Now, he didn't just show his leg. His entire ass, and probably his manhood, were all on display for everyone to see. He did this twice, both on separate occasions. TLDR. Felon evades police officer and gets shot in the butt. He then moons the jury, so they are clear on where he got shot. Not a lawyer, but I worked as a private investigator, investigating workers' compensation/disability cases in Illinois. We got a case in of a guy who claimed a back injury which nobody witnessed. He claimed his back was so bad he couldn't stand for longer than 10 minutes. He had an independent medical exam with my client's doctor, and they didn't notice anything major wrong with his back. His doctor claimed nerve damage or something like that. So they hired me out to conduct surveillance. Immediately after going out there, I found out he was working under the table while he was claiming disability as a construction worker. Over the course of about a month on and off, I was able to obtain no less than 100 hours of surveillance of him performing hard grueling construction work. In Illinois, the laws for workers' compensation arbitration are such that there is no such thing as discovery. This means that evidence does not have to be given to the defense before the case. So they brought me there, and the claimant, plaintiff, sat before the arbitrator. He and his doctor testified for 3 hours on the severe extent of his injury, how he couldn't stand, how he needed job training, all sorts of claims about his inability to work. After the claimant's attorney rested, my client's attorney called me to the stand. I proceeded to begin playing over 100 hours of this man doing literally everything he said he couldn't do. After about 2 hours, the arbitrator called the lawyers to meet in the hallway to discuss ending the hearing due to overwhelming evidence in our favor, during which I spent the longest 20 minutes of my life with just myself, the court reporter, and the man whose testimony I had ripped to shreds and cost potentially hundreds of thousands of dollars in a tiny courtroom. He spent the whole time staring laser beams through me, bright red and nearly shaking point obviously. The arbitrator dismissed his claim and awarded him nothing. I made damn sure he was gone before I went home after that. Not a lawyer here, but since I argued my own case in traffic court I will post point. I and a group of friends had been drinking at a bar since 2 p.m. We left about 2 a.m. You do the math. One friend and I decided to go to an all-night cafe for breakfast. We were both driving our own cars. All went well, great meal, until we left the cafe. The cafe fronted on a 4-lane road with a raised median. I came to a stop at the edge of the road and looked left and right. I was making a left onto the highway. I saw no traffic. I pulled out briskly across the 2 near lanes, crossed the paved median section and promptly T-boned a police car. I hit him hard enough so that he spun around and ended up with 2 of his wheels on either side of the median. About all he could do was turn on his roof lights and hope I would stop, which I did. Point. I was stunned. Where the hell did he come from? I was screwed. Within 5 minutes there were 3 more cop cars in attendance. Unbelievably they did not give me a sobriety test of any kind. I'm sure I was scared sober, but I'm also sure my breath reeked of booze. I ended up getting a ticket for failing to yield right of way and causing an accident. I can only attribute my light treatment to the fact I was in the military, and it was in the 70s, when it seemed the whole country hated both the military and the cops. Perhaps we were brothers in a way. The next morning I still could not understand why I had not seen the police car, drunk or sober. I drove back to the crime scene. Then I understood. On the center median was a neatly planted 3-foot high hedge, planted and maintained by the local garden club. I later found out, just high enough to obscure oncoming headlights at night. I took pictures that morning, then went back at night and took more pictures. I went to court, confessed to being negligent and causing the accident, but also showed the judge my pictures, trying to explain why I had not seen the police cruiser. He took his time, looking at each photo twice. He agreed the hedge was a hazard. He fined me $17. Not a lawyer, but this is too good not to share. Point. During direct examination, I was asked to establish the relevance and chain of custody for several pieces of evidence, including a sheety .22 Derringer that was used in an armed robbery. The Derringer was recovered along with a belt buckle that has a cutout designed to conceal the pistol. They're pieces of sheet and nothing more than hillbilly mullet accessories, but the method of carry went to the premeditation required to establish a conspiracy charge that was part of the case. The prosecuting attorney made sure that my status as a firearms instructor was added to the little CV we give at the beginning of direct, so that our bona fides are established as to specific subject matter areas in which we might be experts. I testified that the gun matches the belt buckle and that both were recovered from sheetbag defendant's sheet vehicle, which he managed to roll near the scene of the crime. A criminal mastermind he isn't. On cross, the defense attorney begins his cross with, "This isn't a quick draw holster, is it? I mean, it's not designed to make it easy to get to the gun in a hurry, right?" As if he was asleep. For direct, sheetbag defendant is beaming, as if he was thinking that this was the moment when it would be established that the glove didn't fit and these weren't even his pants. My response was, "Actually, counselor, that's precisely the intent of this holster. It renders the firearm readily accessible to the wearer from concealment." The state had offered the dingus 7 to 12. He got 27. His lawyer is not awesome, and I would have felt sorry for him if not for the fact that he actually shot at an employee who interrupted his meth-fueled burglary. TLDR dragged through Chinese court bowl, locks with no evidence against us. Not a lawyer, but I was in court recently against the Hong Kong government's Food, Environmental Hygiene Department, FEHD, for multiple violations in regards to one of my restaurants. The FEHD are like the police in the US, is the respect that they think they are above the law point, so we continuously keep getting fined, and we keep asking for what we did. And proof. First time, actually turns out we were in the wrong. I didn't know, so we start doing things their way. Second time, we get a court summons. What the fuck, we did what they said. Plead guilty because barristers in HK are faking expensive. Third time, make up new rules, and threaten to take away our license points, so we end up in court and they are trying to revoke our license. Can't afford the 50,000 Hong Kong dollars, $7,000, for a barrister, so we just go and see the crackers. No legal evidence against us, but we have no defense. Ask for more time to prepare a legal defense, otherwise they will shut us down. Point get a barrister. Still no evidence presented against us. Turn up to court, and the fuck muppets ask for more time to present their case. Thanks guys, that 50 faking grand down the drain. Point get their defense in the post 2 weeks later. 16 pages of the worst written English I ever read. And the only thing suggesting how we solved without going back to court is that we haven't remedied the situation. Huh, what faking situation? You have told us in this 16 pages of bullshit what we are actually doing wrong. Point so pay the barrister yet another $5,000 US on top of $7k we already paid him. Point get to court, and before we get a chance to even enter, their barrister comes over and asks us if we want to settle. Yes FFS. They drop the case with some bureaucratic crap we have to do to help them apparently save face. Another not a lawyer. And this one is kind of sad. Point friend was driving her brother around when she gets hit by a car that ran a red light. They both get out of their cars and start discussing the situation. The woman admitted it was her fault and that she would take responsibility. However, before the cops arrive the woman drives off. Point days later my friend is informed by the insurance that the woman had a different story, so the two parties must dispute it at court. According to that woman, my friend was the one to hit her car. According to her she left the scene because my friend had threatened her with gang violence as my friend and her brother were gangsters. To clarify, my friend and her brother are Latino, but certainly not gangsters. My friend isn't a looker by any standard, and she is that loud person, but she is not a gangster and doesn't look like one, and she certainly didn't threaten gang violence. To put it in perspective, she graduated from a top-tier university, was working under congressional representative, and planning to go into law herself. Her brother was just a college-bound teenage kid, oversized shirt, regular pants. Sort of like poor LA urban kid, but certainly no gangster. My friend was livid about the situation. Her side won, but it's pretty shitty that they got profiled, and in particular her brother who was just a kid that had nothing to do with the situation. Criminal attorney here. Needless to say, the stuff that goes down in criminal courts is often ridiculous. Thus far, I've spent much of my practice in juvenile courts. I remember this one detention hearing. In my state, kids are entitled to a hearing periodically to determine whether they still need to be detained or if they can be released back to their guardians or often a shelter because things are so bad at home. Well, this one kid had ditched school and went mire from his probation officer for about a month and missed his court date. This one probation officer, a notorious softie, had finally had it with this kid. He was recommending detention today and removal from the home after his charge was adjudicated because this was the second or third time the kid had taken off, and then the kid tested positive for hard drugs, meth if I remember correctly, on top of it. In juvenile, POs have a lot of sway, and the fact that this PO was ricksing detention made people pay attention. The kid's attorney went up there and actually said on the record that the kid didn't know about the court date and that she just forgot to tell him about it. Most attorneys are used to the adult side of things, and if she actually knew anything about how Juvie worked, she'd know how easy her lie was to catch. The probation officers are the ones that tell the kids about the court dates, and this kid's PO quickly produced a form signed by both the child and his guardian acknowledging the court date. What a sheethead. Point in my state, Juvie courts follow a progressive sanctions model, meaning you don't just slam a kid right out of the gate. First they have to do a little program with meetings with their field PO and drug tests, then if they screw that up, they have more strict supervision with more rigorous programs, and if they screw up enough, finally removal from the home and or incarceration in a correctional facility. Juvenile law is geared towards rehabilitating the child and making sure that this charge the kid picked up is his or her last. Ideally, a juvenile offender will benefit from the services he receives after adjudication and will never pick up another one. That's the dream, at least. At times I wondered how effective the programs really are, or whether the kids we spend the most time on benefit from them at all. Well, this one kid picked up a pot charge. Nothing serious, first time offense. Usually they get a very lenient regiment that doesn't stick on their record. Juvenile criminal records are sealed by statute after the child reaches adulthood. Well, this one kid really drew the sheet straw because this court-appointed attorney was very stupid and very new. When I explained my offer, he said, well, I guess my theory is that you hit them hard and scare them first, and wanted to put the kid in a very strict and specialized drug court program. This flies in the face of the entire juvenile justice system. And additionally, that drug program has a limited number of spaces reserved for kids with serious problems. This sheethead wanted to put his client in this strictest program that would have POs doing room searches for a first-time pot offense. My partner and I had to basically persuade this attorney into not committing a breach of fiduciary duty, which is kind of a big deal. Family lawyer here who handled a lot of international and interprovincial, Canada, abduction cases, one parent taking a child and fleeing to another place without a court order or agreement of the parties. The opposing party was self-represented. She brought forth a new case years after abducting her children from school several years prior and moving them across the country. The children are with the father now, my client, or living independently. She tried to make a case that the children should be back with her. Her argument being the Supreme Court judges, opposing counsel, the social workers and doctors are all conspiring against me. They are all child abusers and should be found guilty of taking my children from me who are rightfully mine. She basically tried to argue that the system, including the judge she was appearing before, were all conspiring against her. Unfortunately, my client had to fork out over $20,000 to have the case thrown out because every time we would appear, judges would roll their eyes and adjourn it without reading anything, simply based on her demeanor and the fact they instinctively knew they didn't want to hear the case themselves, passing the buck over to some other judge instead. She posted on websites, including Craigslist, the names of every person ever involved in the case, stating that we were kidnappers, child abusers, and should be locked away. The threats continued for months against myself and the law firm I worked with, trying to tarnish our reputations on every comment thread and posting she could make. Needless to say, she wasn't of sound mind, and her behavior/posts made every trip to the Supreme Court feel tense. I was escorted by sheriffs wherever I went in the court during the case and for an extended period after due to her unpredictable and erratic behavior. Still shaking my head over someone arguing the judge in the Supreme Court was conspiring against her after asking a clarifying question about her materials, and before the judge had even commented on the merits of the case. The joys of the self-represented litigant: sometimes never know what to expect. Not a lawyer, but I was in a discussion about the legality of a certain green leafy pungent plant. My opponent in this discussion, a US citizen living in the US, swore up and down that he could not be convicted of anything related to this illegal substance because he did not give jurisdiction to the US government. His reasoning, to the best I could break it down, he believes that he was only subject to natural law, and that the phrase endowed by their creator was a tacit admission that the entire Constitution was subject to those natural laws. In his mind, and he actually used this phrasing, anything that interfered with his right to pursue happiness is automatically unconstitutional. He was not very well versed in constitutional law, to say the least. He went on to apply this to everything, and his next example was riding his motorcycle. He claimed that he was under no obligation to either follow traffic laws nor comply with police officers in the event they would attempt to pull him over. He said if he were caught speeding, he would pull over, but by remaining silent, he would not be granting jurisdiction and the officer would be forced to let him go. All of this with an unlicensed driver and an unregistered bike. It would have been hilarious had he not been trying to convince others of their immunity to governmental law. Another that was participating commented that this smacked of the Bundy idiots that took over that wildlife refuge. That somehow the Constitution would invalidate itself. I guess it's not that weird. My father actually believes that the only power the US legislature has is to provide a standing army. Everything else is not allowed. He's another one that hasn't really read the document. Lawyer here. Two-part story. The worst defense I've ever heard was when a man was caught trafficking his 2 virgin daughters for sex to a gang of wicked men. His excuse was that there were 2 angels at his door and that if he didn't turn over his 2 daughters then the wicked rabble of horny guys would have sodomized the angels. They wanted to know the angels carnally. Crazy, right? Anyway, the judge, God in this case, actually bought it and determined this guy was not only innocent, but he was the only innocent man in the entire city. The next day God destroyed the entire city, killing everyone except the student, his 2 daughters, just having been gang raped, mind you. God also killed the dude's wife when she looked back, because that is obviously a heinous crime. This story gets even worse, believe it or not. The dude ends up wandering around in the wilderness for a while with his daughters and proceeds to have sex with them. Here comes the second craziest defense I've heard. My slutched daughters got me drunk, and I didn't know it was them. The guy actually pulled this card out. I know what you're thinking. There's no way he gets off this time. Well, you're wrong, he did get off. God bought it again, and he even put it in his good book to teach people about morality. Dude's name is Lot. Look it up. I work as a security guard of sorts, and was summoned to witness against a guy I caught stealing a smartwatch and 2 SD cards. He broke the containers for all the 3 items he stole, and the store therefore demanded that he paid for them, which he refused to. Because of a fuck up by me, we couldn't prove that he stole the smartwatch, which was the only thing I actually saw him take, so they dropped the watch from the lawsuit. When we stopped him, I asked if he would kindly empty his pocket. He declined. I said that was alright, but in that case we have to wait for the police to arrive so that they can search his pockets. He emptied his pockets, and we found the SD cards, which he stole right in front of a camera, so it was pretty easy to prove. Point court day comes, and I recite the story in detail. He didn't bring an attorney, so he questions me himself. His argument is that, since I didn't see him steal the SD cards, I detained him unlawfully, and because I informed him that the next step, if he didn't cooperate, would be calling the cops to help me out, I was making threats. He then claimed that this was kidnapping and blackmail. I answer that he did in fact steal the SD cards. He then continues to say, yeah, I did, but that's not why we are here. He was wrong. It was the reason we were there, and he made sure we didn't have to stay for long. First year law student interning at a firm. 2 cases. First case, mother of 3 children had lost her stay-at-home husband 3 weeks prior. Neighbor calls CPS because of smell. CPS comes to house, knocks on door. 7-year-old opens, says mom is asleep. House is a mess. State argues there are no services it can provide to diminish a clear and present danger to the children's life or well-being. Children taken into state custody for indefinite period. Second case, mother and father of 3 children, including 1 newborn with severe health problems. Home health nurse for sick infant comes over, finds child laying in a position that could kill him because of his condition. Smoke in house also harmful to infant's condition. 2 other children. Investigation reveals 2 weeks prior she'd been chasing him down the street drunk with a baseball bat at 2 a.m. and was contacted by police. Father admits to relapsing on meth. State argues the parents are making effort and couldn't show a clear and present danger to the children. Children returned to parents, not necessarily a ridiculous argument in and of themselves. However, the argument that parent 1 presented a non-interventionable danger to the children, but parents 2 did not, is faking ridiculous. I learned there I did not want to see that side of the system, ever. I'm not an attorney and this is actually a pretty common defense excuse in these cases, but I sat through an 8-day trial for a man who had abused his fiance's 2-year-old daughter. He claimed he had sat her on the bathroom counter to go get her a pull-up and she fell off. The surgeons who had to remove part of her skull so her brain could swell outside of it more than 16 hours after he shook the sheet out of her and slammed her head against something. Said the force of her trauma was equivalent to falling out of a third-story window and landing on your head. She's in a wheelchair for the rest of her life, has had to have I don't even know how many surgeries. One for scoliosis, because of her being slumped to the side in her chair, several for her eye, because most of the damage was on one side of the brain, so the opposite side of her body is almost completely immobile and her eye will wander. She can't talk, she can't walk, she'll never do anything point blank. Had also decided to do this on Valentine's Day. She went from being a perfectly normal, healthy, happy 2-year-old to never being able to live her life. He was acquitted. She was covered with vomit and blood. She wouldn't wake up. I was afraid she had choked on her vomit. Her mother, and while awaiting trial he rapped someone and was arrested for driving drunk in the opposite lane of traffic on a highway, but life goes on, sorta. That's the saddest faking thing I've read in a long time. And that's what's faked with the court system. Criminals go free, while innocents suffer, or serve jail time, where they are victims of rap, or possibly murder. It's obvious this guy's messed up. Beats a rap case afterwards too, then a drunk driving charge, and he's still a free man. I went through bullshit stuff that cost me 10 years of being out of my eldest son's life, due to bullshit choices the judge and lawyers made. My son had severe behavior problems, was molested multiple times in group homes that put him in, etc. And still they kept giving him to his mother, who proved she couldn't properly care for him, instead of to me, a father who wanted and loved him dearly, or my own mother who was willing to help me out. He's 16 now, and we have a decent relationship, but I can never give those years back to him that was taken from us due to poor judgment of the very people meant to protect him. He is now in custody of his paternal great uncle, who lives right across from my ex. He's predominantly taken care of my son, very good man, but they still kept giving him to his mom, who still does bare minimum for him. And it's always been one-sided since the very beginning. They claim religion doesn't play a part, but I couldn't get him on holidays, like birthdays and Christmas, because it went against his mom's beliefs. Jehovah's Witness. Plus they told her she could never leave LA County with him. She left the country twice with him. They didn't even slap her wrist. I missed one court date, and my visitation was revoked. Yeah, the system is definitely flawed. As sad as this story is, it doesn't surprise me at all. They get random everyday people to judge these alleged criminals, instead of actual trained professionals. Most don't choose out of fear, like a murder case an example, since if it's a gang member involved, they don't want to become potential targets for having them convicted. Sheet like that. Another one, drunk driving trial, where the defendant was caught dead to rights. I had no idea what she was going to claim, only that her attorney was known to be a real asshole. I had tried a few with him before. During trial, the defense essentially cedes every single element of impaired driving, and the defendant even gets up on the stand and admits to driving drunk. She claims she was at a house drinking with friends when this one other woman got violent and started throwing things, attacking with a knife, etc. She then flees the house and jumps in her car to drive off in fear of her life. Basically, duress. I immediately get a big smirk on my face and proceed to spend 20 minutes of cross-examination getting her to tell the jury how utterly horrible this whole experience was and how scared for her life she was of this other woman. I mean, I really overdid it, even brought her a box of tissues and a cup of water. She fell for it hook, line, and sinker. Defense attorney had no clue what I was up to. Defense rests, and judge asks if there will be rebuttal. I call the officer back up to the stand and introduce a copy of the arrest paperwork from a few hours after she was arrested, where the defendant was signed out of the drunk tank by the woman she claimed to have been scared for her life of. Jury was out for 10 minutes. Best of all, the attorney was overheard a week later telling a judge he was never coming back to my county again. The most ridiculous arguments aren't funny. I've dealt with legal briefs prepared by lawyers that were plainly two different legal briefs cut and pasted together to make one twice as long brief, where the first half of the brief didn't have anything to do with the second half. I dealt with attorneys who argued that my clients violated contracts they signed with third parties not involved in the lawsuit. This is generally not something anyone but the third party has the right to contest. To prove the violation, the opposing counsel included a quote from the alleged third-party contract and a link to where they claimed the full contract could be obtained online. The link was invalid. Upon hunting down the contract in question, it turned out the quoted material wasn't in it. I've seen little old ladies argue that my clients defrauded them by promising to do one thing then doing another thing and holding up as evidence the paper that definitively proved that my client did exactly what it said it would. The worst ridiculous arguments are the ones that get accepted by the courts. I could give a lecture on legal procedure that would be laughed at by other attorneys from other states or areas of law. They'd assume I was utterly incompetent until I showed them in black and white that the highest court in the state had signed off on the things I was saying and that everyone in my area accepts it as settled law. Not a lawyer, but when I was in jail myself a long time ago, was almost murdered myself. That's why I ended up in the solitary confinement ward. They put a guy who was arrested I think for GTA, but was also a witness to a murder, into protective custody. Solitary confinement. Somehow the person he was supposed to testify against was also in the same jail for that murder charge. They managed to not only find out where this other guy was, but somehow was able to traverse all the way across the county jail, LA, and it's huge, trust me, into this guy's cell. Killed him. No witness, no conviction unbeknownst to me at that time. This witness was right next to the cell I was in. I heard a scuffle, but couldn't see anything. All cells face outward to a solid wall, all on the same side. You cannot see anything to either side of you. I heard about what happened the next day through other inmates when I was being transferred to a community block. You have crooked lawyers, crooked cops, crooked judges, etc. I've been arrested many a time for BS charges. Beat most of them, since I was innocent to begin with, but not without spending a week or more till proven such. Innocent till proven guilty. Myers, how the fuck does one person manage to get info on something he's not supposed to know? Then get through many locked doors and units to reach what was supposed to be a protective area. I was a digital forensic analyst a few years ago, and I was called to court as a professional witness for a case where a chap was accused of importing drugs. Usually, I show up at court and I'm told to leave after a few hours as I'm not needed. It's a defense technique. Invite anyone who has anything to do with the case. If one doesn't show, they request to be adjourned until a later time. Anyhow, I was in the ante room next to the court. The lawyers needed a few things clarifying. Fairly standard. Turns out one of the threads the defense was trying to pull was to do with the time that the guy entered the country, and he had a service SMS on his phone welcoming him home and telling him his tariffs were back to normal. Obviously he would have gotten this while on the ferry, so the defense were trying to push it. Sent SMS messages may have the wrong date, as some handsets stamp them with the date/time of the handset, which can be changed. Received SMS are time stamped by the network provider before landing on your phone, and as such can be relied upon. I relayed this to them, and the defense guy said, "How do you know that Vodafone have their clocks set correctly?" I was taken aback and had to say, as I don't work for them, I don't know their time checking or verification processes. He wanted me to say that in the stand. Fine. I was about to step into the court, and I heard the judge say, "Look, he was arrested after stepping off the ferry and had tickets for the trip in his pocket. He was on the ferry. Let's move on." I then got sent home. It just amazed me that a lawyer would consider that a company whose whole billing system relies on time would not have the correct time set. So, I was arguing that a case was moot. Legal theory here: a case is moot if it no longer affects any of the parties. Courts are reluctant to hear moot cases because they are a waste of the court's time, and therefore they will only hear them in certain cases, because the law had changed in between the initial hearing and the appeal, giving me everything requested. The lawyers on the other side argued that the case wasn't moot because a political party had been elected who had made promises to repeal the law in question. They hadn't actually tendered any legislation, so their argument was that a political promise should be taken as fact in the courts. Resulting in this line, the late Antonin Scalia of the United States Supreme Court was well known for his resistance to consideration of legislative debates as an interpretive tool in relation to legislation. C. A. Scalia and B. Garner, Reading Law, The Interpretation of Legal Texts, pp. 369-390, 2012. Canada's traditions are more hospitable to courts using legislative debates for such purpose, but we are unaware of authority for the idea that generalized political statements have the force of law before an enactment. Indeed, if the chief firearms officer is right to speculate, it might equally be that the government could enact to overcome any concerns as raised by any of the 3 questions for which leave was granted. Point note, that's what went into the written decision. In actual oral argument, the question they got hit with was counsel. Has an argument like yours ever been received favorably by the courts? The answer was no. I have to say that I'm no lawyer, but the most ridiculous argument I've heard from a defendant in court is from Delia DePolito. Point, as most of you have seen, she is the cold-hearted beach on a Florida Cops episode who tried to hire a hitman to kill her husband after several failed attempts to frame him for drug possession. She was set up by an acquaintance and introduced to an undercover police officer who was pretending to be a hitman. Point, she was caught on camera clearly paying money for the hitman to purchase a weapon and paying him to murder her husband. I mean, this dirty bitch was caught dead to rights in her attempt to hire a hitman. Point, so she goes to trial and loses. The judge gives this devil woman 20 yards. She appeals it and they drop the faking sentence because of improper juror selection. So they go to retrieve the case, and it resulted in a mistrial this past December with 3 of 6 jurors voting not guilty. I just don't get it. Now listen to her defense. She is saying that her acquaintance forced her at gunpoint to pretend to hire a hitman so the police department could make an episode of Cops and it would make her famous and set her off on an acting career. She says her husband is in on it and everything, which of course he denies. She says the hitman is in on it too, which he denies. I want to know what stupid piece of shit jurors found her not guilty after the last case. That whole argument is worse than if the glove don't fit. Even crazier is that she has since been remarried and had a kid with someone. Who the hell would marry a girl on trial for trying to murder her husband? This is the most ridiculous defense I've ever heard, and sadly it's kept her out of jail at the moment. Not an argument in court, but a letter from the court. I was driving home to California through Utah and was stuck in a snowstorm for a good portion of it that didn't let up till about 50 miles from Vegas. So once I get into the city I stop for gas, spend maybe 10 minutes at the pump because I'm in a big truck, and as I leave the gas station, turning right out of the driveway there is immediately a red light at a big intersection, and I'm waiting there for a few minutes, during which time a motorcycle cop pulls up behind me. The second the light turns green and I start to move, the cop flashes his lights and I pull over once I'm through the intersection. He tells me I was going 40 in a 35 zone. Speeding is speeding, and I'm thinking this is bullshit. You pulled me over when I was at a complete stop, but I'm not about to argue with the cop when I can just fight the ticket later. He nails me for speeding. He nails me for my registration not matching the name on my insurance, which is BS, because it's my dad's truck and we have the same last name, and I'm insured for any car I drive. Grand total of $360. So I try to fight the ticket and they say I have to make a court appearance in Vegas, and I'm not about to drive all that way for a faking bogus speeding ticket. It'll cost me more than that in gas, so I plead guilty to the ticket, and I thought that was that. A couple months later I'm served a letter from the court issuing a warrant for my arrest in the state of Nevada for fleeing the state I don't live in. According to the letter, an admission of guilt and paying of the ticket does not excuse me from missing my court date in Vegas, and I was given a transcript of the hearing that took place without me being there. The cop claimed that he had been chasing a red pickup with California plates and lost him on the freeway, only to find him again at a gas station in town. I was driving a white pickup, Ashford, and that was on record from when he wrote the ticket. However, he showed up to court and I didn't, so fuck me. Statute of limitations ended up being 2 years before my warrant was lifted. I responded to a hit and run accident one night. I find the car had smashed into a parked and the entire neighborhood was outside because they heard the crash. Everyone said they heard the crash and saw the driver get out shortly thereafter and run into her home. She had only gotten 3 houses away from home before wrecking. They all knew her since she is one of their neighbors and described her to a T and what she was wearing. So I go up and knock on the door. She answers, drunk as heck, and before I can say anything, says, "I'm glad you're here. I want to report my car as stolen." I tell her that several people just watched her run into her home from the accident, and she says, "Well, yeah, a man stole my car, and I was chasing after him on foot when he wrecked." I tell her that they saw her get out of the car and she says, "Well, yeah, this guy was stealing my car and I managed to get into the passenger seat and was fighting with him when he wrecked the car." I tell her that she was the only person seen getting out of the car and that she got out the driver's side. She says, "Well, yeah, this guy tried to steal my car and so I was chasing after him in my car. I was trying to run him over and wrecked my car." I asked if she would give a written statement. This was in the days before body-worn cameras had been invented, and she happily agreed, writing down her fanciful story of attempted vehicular homicide. Now there hadn't been another person. She had just went with a silly lie and all I charged her with was failure to maintain a single lane and leaving the scene of an accident. Fast forward to the trial, where she decides to act as her own attorney. She claimed she had been completely sober and had not been the driver. When the time come for her to cross-examine me, she asks, "Can you explain to the court why you didn't have CSI fingerprint the car to try to find the person who was driving it?" I said that there was no need. Several people who were in the court as witnesses had seen her drive. She had said she was the driver and she had even written a statement to that effect. At this point the judge asks to see her written statement, reads it, and then asks her, "Is there anything you want to say about this statement?" To which she replies, "Your Honor, I was so drunk that night I don't remember what I said or wrote and as such none of it shouldn't count." It's illegal and it's incredibly stupid. To you and the client point, every defendant is entitled to a rigorous, ethical, and competent defense. This is our ultimate protection as a society against abusive authority and police misconduct. The fact you have someone in your corner fighting for you to make sure all rules are followed and everything the law says the government must prove is proven. If you get convicted, it is on the strength of the case and the evidence. If a defense lawyer incompetently defends a client, not only is the client entitled to a retrial, the lawyer can be disbarred. So it wouldn't do any good. Doing less than your best just opens the door for a second trial and you're being thrown out of the profession. Plus, if you know the client is guilty, you are still able to ensure process is followed. Not for this client, but for all of us. Because the more often the police get away with bad acts, the more incentive they have to commit more of them. Ensuring police and prosecutorial misconduct results in defendants walking may allow a few bad people to go free, but it is a price we pay for ensuring that innocents are protected from misconduct. People also misunderstand. Even the defense cannot lie openly or allow their client to perjure themselves. If you know an affirmative defense is false, you cannot assert it. You can still do your job by raising doubts where doubt can be raised and ensuring process and procedure is followed.